So I'll just start. That's there. I'll just do the introduction, hand it over to you guys because we're already late. So that's there. So good afternoon, everyone. First of all, welcome to the first PSL Pulse webinar. We would be doing a series of webinars over the next few months and years, getting you information about things which are relevant to the industry. A little bit about PSL Association. We were formally launched on Monday. Uh, and the association basically aims to double the MSCI market in the next 3 to 4 years. This is going to be an association of fintechs, of NBFCs, of banks, and any tech and any other associated partners. If you want to know anything more about us, please feel free to mail me. Most of you all know me from my earlier stint. I'm Prashanth. I'm sorry that my picture cannot be seen, but for some reason my video has decided I'm not good enough. Uh, and before I hand over to the two speakers today, Smita and Supratim, they are today one of the biggest experts. So first of all, thank you so much for coming on board and agreeing to do this webinar. Supratim and Smita have been working with me for years now, and they are today the biggest experts as far as DPDP laws are concerned. And so I thought that we should start our webinars with them because this is one of the most relevant topics. Also, please remember at the end of the webinar, there's a surprise which is going to be revealed while we end the webinar. And I will not take much of your time. I will hand it over to them to start speaking. And so over to you, Supratim and Smita.
Right. Thank you so much, Prashmita. This is absolute privilege for us to be speaking here. Like Prashmita mentioned, this is, I think, right now one of the hottest topics to speak about. The Digital Personal Data Protection Act had come into play, but the rules were awaited, and now that the draft rules are out, it's open for consultation till 18th of February. Two government consultations have already happened. One has happened in Delhi, the other one in Mumbai. I was fortunate to have attended both of them. And maybe as we speak along, we also can discuss some of those aspects which were discussed so that you get a better flavor as to what's happening on ground. With that, I will project my screen and let me know once you're able to see. This is fine. It is visible. Sorry, full screen and visible, Smita.
Sorry, Shupro, before you start, I think we should just let the participants also know that please do feel free to ask any questions in between. You can put up your questions in the chat box. One of us will keep navigating through those and we'll try to answer. The idea is that we make it very, very discussion oriented and not really a monologue. So please do feel free to chime in. You can also look to raise your hand if you don't prefer to type it out. So yeah, thank you.
Yeah, I think let's keep this conversational. That way, things would kind of become clearer maybe as we go along. But Smita, the deck is visible clearly, right? It's full screen.
Yes,
It
it
is,
is.
it is.
Okay, great. So, without further ado, I think we'll get started talking about the act. So, journey has been fairly long. We are aware it's from July, August 2017 that started. Um, so, we have been working from then. Um, and we traveled across the country with Justice Sri Krishna, attended every single consultation meet. And towards the end, you saw in 2023 August how things moved fairly fast. Quickly this draft act bill went from Lok Sabha to Rajya Sabha and ultimately got passed. And on 11th of August, it received presidential assent and got published in the official gazette. But the enforcement related date is yet to be called out in relation to this act. Okay. 3rd of January, we got the draft DPDP rules as a New Year gift. And this is open for consultation, like I was mentioning, up to 18th of February 2025. Possibly there could be a slight extension, but don't rely on that. My request would be that If you intend to give your input suggestions on this, please do it. Try and do it within that 18th February timeline. I will talk a little more about this, but let's, just as a refresher for everyone, let's talk a little bit about the DPDP Act itself. What are the top few things that we should kind of refresh our mind with? One is that this applies to only digital personal data. Okay, it does not cover any non-personal data, which was a thought process in one of the older versions. Okay. Also, no specific obligation on data processors. Everything is on the head of the data fiduciary. Very crudely, let's take an example maybe. All our organizations, we would be giving employee data to payroll service providers, right? And we will tell them maybe first of every month, these 1,000 employees should be getting these respective salaries. So we as an organization, we are determining the purpose and means as to what has to be done with the personal data. So we are data controllers or data fiduciaries, as this law talks about. That service provider, payroll service provider, is basically a data processor. They're simply following our diktat. So they have no liability under this law specifically. So we have to ensure as that organization to pass all the relevant obligation contractually to the data processor. So looking or relooking at your contracts has become most critical right now, because you have to ensure that all relevant aspects, and now the draft rules call out a lot more things, specific things that the processor should be having. You should ensure that all of that gets translated and put into that document. The next point is on transfer of personal data. Again, this has become a bit of a tricky aspect. The reason is when the DPDP Act was drafted, finally, what got settled is that free transferability of data across jurisdiction is possible, minus two catches, two things. One is that the government will come out with a short negative list of jurisdictions. Transacting in data qua those jurisdictions would be restricted. The second thing that it said is that if there is a stricter law, then that will prevail over this general leeway. Simple example could be that RBI says that payment systems related data is embargoed, it cannot go out of the country, etc. That embargo will still prevail over this general leeway. Now, I'll talk as we speak. I'll talk about the rules and how they've tried to do a clawback on data localization in some way. But that's something maybe you would like to take note of. Okay. Next point is there is no categorization of personal data and sensitive personal data and critical personal data, etc. It's a flat structure. All personal data needs to be protected in the same manner. Next point is handling of children's personal data. We know that age of consent is fairly high in India. It's 18 years. In some foreign jurisdictions, say in EU, the GDPR talks about the age threshold as 16 years. It can go below up to 13 years depending on the member state. Okay. What you cannot do is you cannot do targeted advertisement, tracking, or monitoring of children. All of that is embargoed. Okay. The next point is there is no for data breach reporting. This is a very sort of risky one or problematic one. There's a very wide and nebulous definition which has been given in relation to data breach. And if that happens, then you have to go to the data protection board and to the individuals and do a reporting. There is no risk-based or materiality-based threshold for such reporting. So everything needs to be reported. Fairly problematic, just like your certain reporting, etc. Obligation on data processors to notify for breaches. This is again the other issue that is there is like if you look at data controller and data processor relationship, in my example that I cited, the company is a data controller or data fiduciary, and the entity which is providing you the service is the data processor, right? Now, there is no direct obligation on the processor, and you'll have to contractually pass down that obligation. The controller remains responsible for making the reporting. So you, as a fiduciary, would remain responsible to do the reporting to the data protection board and to individuals. Interestingly, this is very different from the cert in reporting for cybersecurity. Now, in most of the cases, you will have to do both the certain reporting and the data protection board related reporting, because a cyber breach will in most of the cases probably also include some personal data, and therefore even data protection board needs to be made aware of it. Interestingly, what CERT-in says is that in case there is a breach, then whoever observes it, whether it is a data processor or a controller, they have to report, and you cannot contract out of it. So in this case, there could be a bit of a dichotomy as to who reports and how. Probably the best case scenario is you put in your contract that in case there is a data breach, the processor is also supposed to report to the relevant bodies and parallelly and immediately let you know about this breach so that you can also fulfill your obligation. We'll talk more about this because it's a very interesting area and tricky and problematic area as well. Last point, high financial penalties based on certain parameters, but thankfully no criminal sanctions, no imprisonment provision is there. So that's a bit of a refresher. Again, coming back to the rules, we just spoke about it. Rules are out, open for consultation up to 18th of February. Once that consultation gets over, what happens next? Okay, it's an obvious question. Next is, there would be, the government will take some time to assimilate all the inputs that are received, and then this rules could be brought into play. Okay, and when that happens, what happens first? The data code related provision come into effect immediately, and then probably a timeline of about 18 months to maximum say 24 months could be given to operationalize the act as a sunrise period. But a word of caution here, that other jurisdictions such as say European Union when GDPR came into play, etc., showed us that when they got 2 years for a jurisdiction like EU who already had a law and were just taking one step up, it was quite difficult for them. Okay, 2 years was not sufficient for them. For a country like India, this will be a quantum leap, almost from nothing, no law to a law equivalent to GDPR. We will take a lot of time. So, might as well start preparing from now onwards. And how do you do it? We'll talk about it, but in very, very brief, I would tell you, at least start with the workshops and training of your privacy champions. That is, people who are there in your organization in the different business functions who would lead this privacy related exercise going forward. Ideally you should choose people from all the business functions such as say HR, IT, marketing, communications, all of those, and they should be doing at least a half-day workshop to understand this threadbare, because they have to take this journey ahead for the organization. The first thing under this particular set of rules, which is worth mentioning, is regarding notices. Now, what does this law say? Anyways, the act itself was talking about specific and granular kind of notice being given to the users, or people from whom you will be collecting the information. So data fiduciaries are required to publish a notice providing a fair account of the details necessary to enable data principals to give specific and informed consent for their processing of personal data. Interestingly, this notice is to be presented in an understandable and independently of other information. So probably now you'll have to think that one sentence that we write, you agree to our privacy policy and terms of use, and there is one tick. Probably that will now have to change because they've said that the notice has to be independently given, right? So ideally there should be like two ticks probably, you have to have that, okay, this is a privacy policy link, this is the terms of use link, because privacy policy will cover most of the things of what you have to write in notice. There should be ideally a different kind of line item for that. This means distinguishable from other information made available by the data fiduciary, such as contract or terms and conditions. Important to note point number 3 here. The notice should include the following: itemized description of personal data sought to be processed. The specified purpose of processing such personal data, and itemized description of goods or services to be provided or uses to be enabled by such processing. Now, I'd pause there and talk a little bit about the consultation meets that are happening at present. And there are, some, sorry, one second. Okay. So if you look at it, when we provide the purposes, usually it would be a running statement or a running paragraph, etc. Okay. The way this is drafted, the rules are drafted, it means that we have to be more granular about it. We have to write that, okay, I'm taking name, email ID, and your phone number for the purpose of, say, account creation, etc. So that kind of granularity has to be worked on, I think, from going forward from here onwards. Okay. Um, and then the last point here is that data fiduciaries must provide a specific communication link to access the platform through which the data principal may withdraw consent and also exercise their rights under DPDPA. This, I think, has been the move of the government for quite some time, that you can't just say that you write to us, etc. Try and provide links or avenues through which the individual can easily access how to withdraw consent, how to exercise rights, including right to go to the data protection board if there is a requirement. I think there was a question, Smita. Sorry, I just saw ping and
Yeah, we've received two questions.
hmm.
Should we take that up right now?
Yeah, I think let me just see if I can, and then maybe after that we'll straight away continue. Is ISO IEC 27001 standard concerned with DPDP? If yes, is it mandatory for institutions or organizations to offer? Very good question, Dr. Raj. Um, so if you look at the present day law, okay, which is Information Technology Act and the sensitive personal data rules on a sector neutral basis. That talks about having ISO 27001 as a standard, okay, to kind of be at par with whatever reasonable security practices and procedures have been mentioned. Under the new rules, they have not called out any specific standard yet. Okay. They have given certain broad thumb rules as to what all you need to do at the minimum, but they've still not called out any specific standard. It's good and bad. The government wants to showcase that, listen, we have told you the parameters. Now it is up to you to use whichever standard, whichever methodology you want to use. But the industry thinks that probably a particular standard would have been much more helpful, because then they would specifically just opt for that standard being adopted and get done with it. Okay, because this is a bit nebulous. You might be thinking that you are doing obfuscation or encryption, which is good enough for what has been written, but in a bad day the regulator may think otherwise, right? So that's a problem area, and I would encourage all of you to give your inputs on these government, because the consultation is still on. Is there another question?
Yeah, there's one more.
Yeah, I am unable to.
From, should I just read it out?
Yeah, just give me one moment. I'm not sure why I'm not able to read. Yeah, just read it out. Sorry, Smita.
Yeah, sure. This is from Mr. Pankaj Srivastava. His question is, we contribute CSR funds to Tata Hospital as our CSR implementing agency under the Companies Act for treatment of cancer patients. Tata Hospital identifies the patients and collects all the patient details. In this case, who will be identified as data fiduciary, them or Tata Hospital?
See, I think, and of course, we'll have to drill down and see the granular level arrangement. But if you are not determining any purpose and means as to what has to be done with the personal data, and the touch point is personal data, then you are not the data fiduciary. Okay. So therefore, in your case, it appears that you are only concerned with giving the money to them, and they are in turn determining the purpose and means as to what has to be done with the personal data of those individuals. So in this case, purely from a data centric perspective, they would be the data fiduciaries. I think there's one more question which has come.
I can't see any other. Has it come to you? I think some of the questions are coming directly to either of us.
Yes, possible. So I think this is Dr. Raj again, in continuation of my previous question. In every sector, government laid the standards, why not in DPDP? So I think, of course, it's in their wisdom that they have not laid out, but probably some background I can provide. Um, when the IT Act and the SPDA rules they were getting rolled out and ISO 27001 was called out, there was also a bit of hue and cry that time that why ISO? Okay, there are so many standards, etc. Why not something else? And things like those. So therefore, in order to probably alleviate those kind of concerns, they have brought out some parameters, but they have not called out the specific standard. Okay, so I'll move on. The next point which I wanted to talk about is data breach intimation. Just one second. Yeah. So I think this is, I was just mentioning briefly at the beginning, this is something that you all, I would recommend must put a representation in relation to. Reason is, in a bad day today, if there is a cyber incident, anyways, within 6 hours of observing it or being brought to notice, you will have to report this. Okay. Um, Additionally, you are required under this act and the rules now, you are supposed to do a three-pronged approach. Firstly, you have to immediately go to the data protection board and give some minimal information. Within 72 hours, you have to again go and give them a lot more information. The line items are all provided here. Separately, you have to also go to the individuals and report to them as to what has happened and do a reporting to them. Interestingly, the 72-hour breach reporting that is required to be done, one of the line items there, which you are stating to the data protection board, is report on the notification made to the individuals. Therefore, de facto, they are assuming that in 72 hours, you have also already informed the individuals. Now, we handle data protection, their data breaches and incident reporting almost on a daily basis. Trust me, in 72 hours, you will understand nothing. Okay. But if you are required to go to a regulator and tell them few things, that's still okay. If you go to all and sundry, say like 5 lakh people were impacted, if you write to them with some vague information, they might just get panicked and you will get say 5,000 responses back and a lot of random questions. So you have to then channelize your energies to really respond to those rather than channelizing your energies to contain the breach and see that your things are safe. So two things. One is breach reporting should be better streamlined. In a bad day, organizations should not be running from pillar to post to report to certain, to Data Protection Board of India 2 times, to individuals and also to sector regulators, say RBI, IRDI, CERSI, depending on what has happened, right? So this is something maybe you can think of as an input. Next, this was what we were talking about regarding reasonable security safeguards. Some of the things that have been mentioned in the rules, the draft rules, are this technical measures such as encryption, obfuscation, masking, and these are all minimum threshold. Okay, at the minimum, they want you to do this. Okay, you can do more, but just look at this, how much has to be done. Implement appropriate access controls to computer resource, monitoring and logging requirements to prevent authorization access and maintaining the confidentiality of personal data, continuity measures to ensure the availability and integrity of personal data, retention of logs for breach detection for a period of 1 year or more. Interestingly, this is in a way conflicting or is more than what the CERT-in is asking. The CERT-in asks that for 180 days rolling basis, you should keep your logs. Okay. This one says that if there has been an incident, then you retain the logs and the relevant personal data for 1 year. So this is going over and beyond. I think there's a question here. We have the IT Act 2000 now with several amendments. Why there is a need to separate act like DPDP? DPDP can be incorporated in the IT Act only. See, so I think there was an attempt, if you see the Information Technology Act, and you rightly said the amendment, for example, the 2008 amendment brought in a couple of sections. Section 43A, which talked about sensitive personal data and then the sensitive personal data rules. And also then there was a section 72A, which was dealing with personal data. But it was seen that A, it was lack of enforcement, and B, what was written there was not good enough for the present day world, considering all other legislations have gone far ahead. Okay, globally, the data protection laws are standalone legislations covering much more. So therefore, there was this intent to cover much more and things in greater granularity and detail. That's why the DPDP Act was brought into effect, of course, including the landmark Supreme Court decision, which had to be given effect to on right to privacy. Next is significant data fiduciaries. Okay, this is, you are aware that there are two kinds of data controllers that this law talks about. One is a normal data fiduciary, like all players. And then if you are crunching high volume of data, more sensitive kind of data, or there is possibility of risk to individuals and potential impact to sovereignty, integrity of India or electoral democracies, security of the state, then you could get categorized as significant data fiduciary. Who will these players be? That has still not been talked about. In the recent Mumbai meetings of the ministry, there was again a request made, but the ministry has said that this will be, of course, a separate notification which will subsequently come out. I requested the relevant officials there that listen, this is a very critical item and this notification should ideally come out at the earliest. The reason is that the people who are running at 20 will have to start running at 120. A lot of things have to be done by these significant data fiduciaries. Having a DPO in India, data protection officer in India, doing data protection impact assessment, and now additional things have also been called out in the rules. They're saying that you have to do annual data protection impact assessment and audit, and the takeaways from there have to be, the key aspects from there have to be presented to the data protection board. Now, interestingly, till date, the data protection board was never supposed to do all of this. They were supposed to be largely an adjudicatory body. Suddenly, through this provision, they have been told that you will have to also provide the key aspects of the report to the board. Also, these players have to do algorithmic due diligence. So they're saying that significant data fiduciary must undertake due diligence to ensure that algorithmic software used by them for handling personal data is designed and verified to safeguard against any risks to rights of data principles. So if you can observe what is happening, probably in the absence of a dedicated AI related law, we are trying to indirectly try to see that AI related impacts are mitigated through these measures. But there are a lot of questions and counter questions which are being raised. One is that why should it be for this kind of players only, uh, which is significant data fiduciary? There are other things like on data localization. Okay, so my data should be housed within my own country was kind of getting done away with when you look at the DPDP Act. But it seems like through these rules, they have tried to bring this back, especially in the context of significant data breach. I'll come to that point separately, but this is something which is a watch out area for large players at least, or players who are crunching critical, more critical and more sensitive data. Specified retention. Interestingly, there are three players who have been called out. Social media intermediaries with more than 2 crore of users, e-commerce entities with more than 2 crore users, and online gaming intermediaries with more than 50 lakh users. They have been told to delete the data in 3 years. Okay, so this is something, again, the question is why only these players? For others, of course, it remains the same, like, up to the purpose of that particular data up to which you can use it, and or if there is any law which is asking you to retain the data for that period. Okay. This is the last slide that I would cover, and then I would hand this over to Smita, which is international data transfer. Like I was mentioning that in the DPDP Act, it was almost like free transferability of data minus those two catches, two important aspects. One is if there is a stricter law that will prevail over this general leeway. And the second one was that the government can come out with a short list of negative jurisdictions and things could be embargoed. Data transfer could be embargoed. Who are those jurisdictions? But now what do we observe? We observe two things. One is for all kind of players, they have said that in case the information is going to another country, the government can, through either direct or a general diktat, tell you that whether the data there should be looked at by that government. Now the problem is that every jurisdiction will have some kind of surveillance laws. Okay, it's there almost in every jurisdiction, including India. If you look at Information Technology Act, Telegraph Act, the government can ask for information. Now, if the government is stating that if the data is going outside to another jurisdiction, it cannot be looked at by a government or a government agency there, how do you test it, right? You probably would have to do something like transfer impact assessment, which EU is doing on other countries where they're sending data. And if you observe, almost every country again will have some kind of surveillance related law. So it could in effect mean that indirectly we are trying to bring in data localization through this mode. This is for all kind of players. Now coming specifically to significant data fiduciaries, the problem is they have directly called out that for these kind of players, it could be certain kind of data which could be embargoed and that has to be kept only within the country. Now, again, I'm going back to my point that this was supposed to be not there, like for all kind of players, all kind of jurisdictions, certain kind of information being not being able to be sent, etc., was kind of getting done away at the mother legislation level. Suddenly, in a subordinate legislation, which is the rules, they've tried to undo the data localization related aspect that was written. Okay. So with this, I'll unshare Smita and I'll hand this over to you. But I think there's one question which I can see. Uh, I think Dr. Raj, you say that don't you think, sorry, there are two questions. Don't you think privacy is in both the acts and many other things which are duplicating? No, so what will happen is, Dr. Raj, that once the DPDP Act comes into play, the section 43A and the sensitive personal data rules will be, will be ineffective. So that will get scrapped from that law. But yeah, there are some duplications which will be there. Like, for example, section 72A still continues, which I agree with you. I think, Pankaj, your question is, can we cover all employees related data under legitimate users exemption, which says for the purpose of employment, or there will be any restriction for that exemption? See, till now, when you read the black letter of the law, it's a wide parameter, right, for purposes of employment. But I would suggest that trudge this with caution right now. The reason is that India understands consent very well. Other legitimate uses and purposes, etc., have still not been tested very well in India. So some things which are way before the employment or way after the employment, if you're trying to bring it within the fold of for purposes of employment, be little careful. But within the fold of employment, I think you have enough flexibility. Okay. Next question is whether official email ID, or I think it's a part of the same question, whether official email ID and mobile number is personal information or only personal email ID. Suppose a regulator, a vendor, a customer asks for email ID of any officer or KMP, whether notice consent requirement will be applicable in such case. So I think this one, I think you can cover within the purposes of employment, and you may craft your employment contract, handbooks, etc. appropriately so that this kind of gets within the fold. So I think that's about it from the question that I can see, unless Smita, you see other questions also.
No, I think even in my chat box, those are the ones.
Perfect. Okay, great. Over to you.
Thank you. Thank you, Supratim, for that fantastic setting the background and taking us through the important provisions. I think I'll quickly move on to the balance part of the presentation that we put together. Um, we'll start with the concept of children's personal data and how it has been dealt with within the Act and the rules.
I'm sorry, Smita, this is not full screen still. So maybe
It's not.
no, I still see it as a non-full screen.
Is there a lag? Uh,
Yeah, I think I'm still seeing yours, Shupru. I'm not seeing hers actually.
Oh,
Okay, let me just try to share again.
this unshare and reshare.
Yeah, yeah, yeah.
Thank you, Dr. Raj. Very happy to have answered your question. Yeah, this is perfect now, Smita. Please go ahead.
This is fine, no? All
Yeah.
right. Okay. Yeah. So we'll quickly move on to the rest of the presentation. The first thing that I'll be talking about is how the rules and the act deal with children's personal data. Supratim had already mentioned that the age for consent in India is 18 years. And that brings us to a situation that where fiduciaries are dealing with children's data. How do you really go about getting legally valid consent? The idea in that situation is that it needs to be verifiable parental or guardian consent. That's all that has been mandated so far. And this applies basically to a situation where the personal data pertains to a child below the age of 18 years or any person with disabilities who doesn't really have the ability to provide uh, consent in the legal form. In both cases, you take the consent either from the parents or whoever are the legal guardian for such persons. Um, the rules do not provide for any kind of obligation on data fiduciaries to verify the relationship or kinship between the person whose data is being processed and their parent or the guardian who's providing the consent, which is frankly quite strange. But if you think about it in spirit, in terms of what the rules are trying to achieve, the idea would always be that data fiduciaries actually go about undertaking proper form of due diligence and having enough evidence to show that whoever had provided that consent, a there was some sort of a relationship, and secondly that person himself was an age of majority above 18 years. How can this be done? I think the idea would be that your usual channels of KYC, which are being deployed, and financial services as a space would be fairly familiar with that, is something that can be deployed. You can potentially look at doing verification through uh, regulatory authorities, uh, or you can try to achieve or get services of some of the authorized entities like DigiLocker and all. So even where the law does not mandate that a relationship has to be established, the prudent thing to do would be to carry out a due diligence on the guardian or the parent who's providing that consent. And uh, yeah, so that's on children's personal data. We are aware that this particular concept may not be that relevant for the participants here, given the financial services background. So we are just quickly moving on to the next concept. One of the important thing that DPDPA actually brought into existence was basically the concept of consent managers. I think one of the questions was that why isn't IT Act itself sufficient, and why can't we just go about amending the IT Act itself, and what is the need to get a new law? I think one aspect is, of course, a robust framework for privacy. But one of the other things that the DPDPA does is also introduce these regulatory bodies or different kind of entities who can be entrusted with doing various functions in this ecosystem, for which IT Act by itself was not sufficient, and the idea was to have a framework which is sufficient and complete by itself. And that also provided an avenue to the government to introduce a concept like a consent manager. So, picking up from that, what exactly is consent manager as a concept? Considering it's the PSL Association, I think most of the participants, I would imagine, would be familiar with the construct of account aggregators, which is nothing but an intermediary who can facilitate uh, transfer of financial data relating to customers from one financial institution to another financial institution based on a one-time consent that a customer provides. What that basically means is that every time a financial institution requires financial data of customers, they don't really need to avail fresh consent from the customers, and customers do not need to put in specific effort in fetching their bank account details, loan history, etc. from one bank and then provide it to another. It can simply be transferred between two financial institutions without much ado. Consent managers, frankly, is sort of based on a similar concept as account aggregator. The key differentiating point between consent managers is that we are basically talking about personal information and not just financial information, which is in the account aggregator domain. The second key differentiating factor between a consent manager and account aggregator would be the regulatory push. For account aggregators, firstly, the regulating authority is RBI, which obviously not just provides for registration or operations of how account aggregators should function, but also pushes financial institutions who are participants in that ecosystem to actually provide that data and extend that coordination. Unlike that, so far, the DPDPA does not talk about um, uh, any kind of push or mandating the data fiduciary to necessarily coordinate with consent managers, or where a customer has provided consent, provide that data to consent managers and enable that ease of functioning and also ensure privacy protection. That really brings us to a situation that if a fiduciary is not mandated to provide that data to consent manager, through whom it data could actually be transferred to another data fiduciary, provided the customer has given consent, how exactly is this system going to work? Because the idea right now appears to be that all data fiduciaries need to independently come together, see value in the system, and then adopt it. Or that's the only situation in which this model is going to scale up. Uh, Frankly, there are no answers to that, and a lot is going to be dependent on the fact the kind of business models which actually come about in working for consent managers. Before we really get into what kind of business models can be adopted by consent managers, there are two, three very, very critical rules that need to be kept in mind when we talk about consent managers. One is basically the consent manager is expected to be data blind. Their job is going to be similar to traffic controller. What that means is they can only provide an avenue for data to be transmitted across to data fiduciaries. And secondly, they are fiduciaries to customers, right? So when I have provided my consent to a consent manager that this is my data, XYZ are the purposes for which it can be transmitted within the ecosystem across data fiduciaries. Their job is to ensure that that consent architecture is basically deployed and is followed through, which becomes very difficult for them because they are not eventually the people who are going to be utilizing that data. um, the second thing to note is consent. There cannot be any form of conflict of interest between consent managers and data fiduciaries, which will basically bring us to the question then how exactly the economics or commercials of this model going to work. And third important thing that I would like to point out is there is no subcontracting or assignment of obligations which is permitted to for consent managers, which brings us to the question that uh, like we see in financial services a lot many times tech stack or some of the ancillary functions are actually outsourced to other entities just to ensure that it is basically being financial services are being facilitated in a manner and the customer access is easier. That by itself has created an ecosystem of various service providers, and fintechs frankly have basically thrived on that opportunity which is available as a part of outsourcing. Consent managers don't really seem to have that avenue. And with that, I would just like to talk about some of the business models that the industry has been thinking about as consent managers, and also the fact that consent managers as a concept or the business models that can be deployed was actually thought of as a part of the DEPA paper that was put together by Niti Aayog, which was for discussions. I think this was back in 2019, and eventually in the subsequent drafts of the data protection bills, based on even the Joint Parliamentary Committee had picked it up, and there was substantial amount of discussion around that. um, DEPA as a paper is very, very interesting for people who wish to understand what the consent manager architecture should basically look like and potential business models. But how exactly does that tie in with the rules? That is still a question mark. So I'll just quickly give you a brief around what all is being thought about uh, in terms of how to really get into the skin of consent managers and get that registration. There are four models that Niti Aayog had basically proposed as a part of DEPA paper. One was a straight out model where the services, because those are being provided to data fiduciaries, and the fact that conflict of interest in this domain necessarily needs to be avoided. The idea was that because this ecosystem is going to make customers' lives easier, the money or the commercials of it could be in a manner that it's a fee-based structures where customers pay fees to consent managers for processing those consents and providing for interoperability of information sharing, etc. Now, the question that we as a society or as people who are supposed to be beneficiary of this legislation need to ask ourselves: Are we really ready? How much do we value our own privacy and the ease of sharing of that information? Are we willing to pay to a consent manager for just processing our consent? Frankly, if I am going to use, let's say, 100 e-commerce platforms, would I want to pay a small fee to a consent managers who can just, provide all my information to these e-commerce entities, and I don't really need to enter all of that information? Or would I not want to shed that fee and and keep providing that information? Is really a question mark. I think it will depend on a lot of people and personal perspectives that people may have around that. Um, the kind of economy we are, it may be slightly difficult to convince the customers to actually make a payment for that. The other model that was talked about in that sense was that why not have the data fiduciaries subsidize this cost? And that really becomes directly in conflict with the conflict of interest principle that has been prescribed. Fiduciaries as the beneficiaries of data, if they have the ability to make a payment for that data, then there is an inherent conflict of interest, and that's something that needs to be worked out. Of course, there can be safeguards, arm's length pricing, etc. Is that something that can be looked at? I think it would be good to utilize this time of consultation with the ministry and provide that kind of feedback. The second model for consent managers could be potentially, in-house consent manager systems, which basically maybe work in groups or in group entities or big conglomerates of financial services, who can have basically one consent manager license within the group, and their job could be to ensure interoperability of the information and data sharing. Again, conflict of interest as a rule is going to be the dominating factor in terms of how exactly do you go about doing the pricing, and again, whether the money comes from customers or does it come from the data fiduciary. The third model could be what the account aggregator system has achieved, where a lot of PSUs have come together and set up account aggregator entities and all. We could potentially look at something like that, which is maybe government owned or a government instrumentality owned, and that makes it basically very, very subsidized for customers. And we could just look at eliminating any kind of additional cost to the customer. Um, Fourth model could be a more evolved sort of a consent management architecture where there is a consent manager. They do their primary functions, but because they have the capability and wherewithal, there could be certain degree of value added services that consent managers provide, whether in form of analytics, of the data which is flowing through them, and that will provide opportunities to make it more commercially viable for them. Now these are all out there in the open. The way the structure currently is, we can't really say that one model is better than the other or is being promoted by the rules. I think it would be good to have more and more consultation around this, and also understand from the ministry what the outlook is. Outside of this, there are general obligations on consent managers. They need to have auditable records. They need to be completely data blind. There are transparency related requirements. And also, consent managers need to be completely, they need to be India incorporated companies. It doesn't look like that there is a restriction on foreign investment. However, I think it may be worth clarifying with the ministry on those aspects. So that's on consent managers. I'll just quickly take a look at some of the questions that we have. One of the questions is from Shubham. Can we see consent managers as our advocates for protecting our personal data, as in consent manager will prevent other fiduciaries from exploiting individuals' personal data? So, Shubham, the way the architecture is proposed right now, I don't believe they have their duty is to go out of their way in terms of protecting misutilization by data fiduciaries. The idea is more about making it easier for customers and data fiduciaries to utilize that consent. Will they have and the other thing to keep in mind is that consent managers by themselves are basically data fiduciaries. So, to the extent any data that is being transmitted through the consent manager or through the consent architecture, if there is a breach by themselves on those obligations, then of course data principals will have a recourse against them or will have the ability to complain to the board. But to the extent the fiduciaries themselves are in breach of obligation or whatever consent architecture that has been specified by consent manager. Right now, the legislation is completely silent on whether the consent manager will have a recourse against data fiduciary or not. I think looking at the account aggregator framework, I believe the way this is likely to work out is that there will be a lot of contractual protection and rights and avenues that consent managers will have in terms of breach of any of those obligations. And in that case, it's possible that there is a recourse to the board in terms of complaint of data fiduciaries. But if we are looking at as an active role that consent managers will play in privacy, I don't believe so. I would slightly be held back on that purely because of the commercial nature of this ecosystem which is trying to be created. So the avenues are going to be restricted in terms of customer relationship with the consent manager vis-a-vis managing their consent, and consent managers relationship with the fiduciaries who are basically onboarded with those consent managers. So let's say if I'm not onboarded with a consent manager, I can't really have that expectation to go to the consent managers and say XYZ fiduciaries are misutilizing my information. So that I believe then your redressal is going to be with the grievance redressal officer of the fiduciary, or you go to the board. Consent managers, I don't believe are going to be playing an active role outside of their own services. There's another question from Vikram Gar. No, sorry. Okay. Then there are certain rights of data principles, which is corresponding to the obligations of data fiduciaries. I'll quickly flip through this. I'm aware that we are already sort of breaching the time limits. One is that data principles, we have basically the ability to seek information from data fiduciaries to tell us what exactly is our personal data being processed for, who are the people who will have access to that data, whether for processing or meeting any of those purposes for which we have given the consent. There's also a right of grievance redressal. Every fiduciary basically needs to provide a grievance redressal mechanism which needs to be easily accessible to data principals. So it can't really be hidden somewhere in the privacy policy, and you have to spend a lot of time just trying to figure out who to reach out to in a breach kind of a situation. Then, of course, there is a right to nominate. You can basically nominate individuals who will, in your death or in incapacity, be in a position to deal with your data. A right of correction and erasure of data. So, this is basically a real problem. There are a lot of websites and platforms, etc., where a lot of our personal information is stored. Many of it is inaccurate or is required to be updated. Frankly, as a matter of right, we don't really have any avenue to get that changed. But with the DPDPA coming into force, this is something that's going to be available. And the idea is that fiduciaries provide that avenue for erasure, correction, and updation of data. Yeah, so, again, taking it forward from there, the idea for data fiduciaries is also to publish details of how rights can be exercised. So this is something that data principals need to be given access to, or made to be understand that this is how you need to go about exercising your right. You have the avenue to go to the grievance redressal. From there, you can go to the board, and so on and so forth. There is also a requirement to provide response time for grievances, and uh, data principals are also allowed to designate third parties to exercise their rights. There are certain exemptions for data principals. One is tracking of behavioral aspects of children or people in cases of clinical establishments, healthcare professionals, educational institution, creche or childcare facilities. I mean, it's pretty obvious that why this is something that would be allowed, and the only issue is that the way educational institutions is basically defined, it makes it very, very wide in terms of including any institutions which impart education or include vocational training. That basically means our edtech platforms completely exempt from the requirements and all. So that really becomes a question mark. Then research, archiving, statistical purposes are also something which are exempt, but obviously certain subject to certain requirements. Um, so long as you're meeting these requirements, these are some of the purposes which are exempt, which also makes it very, very difficult to assess, and sort of provides a loophole for many organizations, because what is archiving or what is statistical is something that is, or what is research is basically debated. It's something that can be debated. Calling from data fiduciary or intermediary, government has been given certain wide powers to basically call for information from data fiduciary. Um, uh, th- uh, um, uh, Positions like sovereignty, integrity, and security of the country are obvious exemptions. Performance of state functions or disclosures under applicable law are basically also situations which are exempt. um, and assessment for notifying significant data fiduciary. So, for government to know which entity needs to be a significant data fiduciary, they will obviously need to understand what is the kind of information which is being obtained by significant data fiduciaries. And in that sense, it becomes really important for the government to have that right. So, that's also been given as one of the exceptions. Quickly, I think the last slide I would just like to talk about the quick takeaways for financial services entities, I think there are five things which should be the key agenda for any FS entity. One is the notice requirements. Please go over, your present consent architecture and ensure that your customers are basically prepared for providing them notices for existing customers that we have so and so information, and we will continue to use it and process it. Should you have any objection, please reach out to us for deletion or erasure of information within the statutory limits. For instance, if you still need to process that information for loan monitoring, obviously there is no right the data principals have to erase that information. Then implementation of reasonable security practices. Now, for financial services entities, I would be less concerned because obviously DPDPA does not really mandate any specific kind of standard that need to be followed. And frankly, an RBI or SEBI is already very, very specific about what needs to be followed. So I think we should be home there. But the idea would be to keep a lookout for what the DPDPA rules finally prescribe and ensure that we are basically following the best of both worlds. Reporting of personal data breaches. So far, we've only been doing it to the RBI. I'm talking about FS entities. Now, the idea would be to build in specific structures around informing the data principles as well. Sorry, I missed certain, but that's anyway built into your existing obligations, and then eventually informing to the data. Sorry, just give me 1 minute. Data board as well. And then additional obligations of significant data fiduciaries. Most FS entities, our sense is that are going to be prescribed as significant data fiduciaries. So, some of those additional obligations like impact assessment, undertaking proper audits, etc., is something that will have to be followed. It's just better to gear up for that. I think with that, I'll just close the discussion. I'm extremely sorry for overshooting the time.
Smita, you did not overshoot the time. We had kept it for 1.5 hours. So, so that's there. But now we have a surprise guest, which I've been talking about. Vikram, if you could come online. So
Yes.
we have a surprise guest today, which was whom we wanted to introduce. Vikram is a senior fellow at iSpirit, a change management lead consultant. He's an accomplished executive with experience in public tech, business information, and responsible for AI and digital strategy. He's also a certified independent director. Now, the surprise is that we will now have a small little discussion on DEPA and how to unlock the proprietary data there. And beyond this, Vikram will speak to you. And before we end, we'll tell you what is the surprise. So over to you, Vikram.
So is my slide visible? And am I audible?
Yes.
Okay. So just to give some idea on I'm from IT side. I'm not from the lawyer side or legal perspective side, but I'm bringing a digital perspective to this section of understanding of what we are doing. So Indian digital journey is very unique, if we see that. We have been very good in creating products. Oh, sorry, we have not been very good in creating products, but we are very, for example, if we take an example of semiconductor industries or hardware, storage, networking, we are predominantly in the service in nature. And same happened with the software as well. So are we very prominent in software? No. We have some products, but very limited. So we are primarily in the customization, configuration, and providing services, O&M services in the IT space. But we are known for the software. We are known for the software tail end of that perspective. So I have a journey to make India as a digital India. We uses this digital technology and deployed it at scale for our governance, which we totally today called as India Stack or digital public infrastructure or public tech. Now, even this technology is hugely in demand in Global South. And we are also well known for creating brand for India. So this DPI for India is really making a lot of difference to us. So if we see from that perspective, there is this DPI for AI is only a additional step overall the DPI which we have already created for India. One is the flow of people, and Aadhaar is the basic, but above Aadhaar we have built eKYC, e-sign, and then flow of money, which is primarily UPI, and then again over and above UPI we have built ONDC, FASTag, and GSTN network. So these are the flow of money happens. So this is all India stack, we call it. And then we have come with the flow of info, and one of them is DigiLocker, and as Smita said, account aggregator also built over above that, right? And now things are coming through OCEN, and now we will also coming through DPI for AI, building that. So we are all aware that artificial intelligence is going to make a big difference and major disruption in the worldwide. It's a globally going to happen across the business function as well as the government function. So AI majorly is built into two pillars. One is the logic, which we can call it as a model, and second is the aspect is the training the model. Now, if you have to train the model, you need data. However, when it comes to specific tasks, we have to do a fine tuning of the model. So what happens is, if we have to say that we have to have an AI model which does a good function in BFSI space, then we have to fine tune that model into BFSI space. If it is a health sector, then we have to model it on the health data. For example, we can predict the using the X-rays that what is likely to happen, what is unlikely to happen. So we have to read millions of X-rays and whatever the outcomes in the past has happened, fine tune that model so that results can be achieved. But challenge for us is how to unlock this data, which is proprietary in nature, which is also available with hundreds, thousands of data fiduciaries distributed across India. And now suddenly we find that DPDP Act is here, and then we feel that it is a blocker, and it creates problem for us to how to drive things. But is it really a DPDP Act is a blocker? Unlikely, because at the end, AI is going to create good teachers, a smart doctor. It is likely to work in most scenario in assistive mode. It will say, keeping the following and past historical data, this is expected. The patient is likely to have this. But then the doctor would be able to do things that what is the likelihood that this person is likely to have. So keeping this in mind, DPDP Act emphasizes on consent. If we keep this, if we see that perspective, it largely talks about that with consent you can do anything. But without a consent, you face a challenge. And it also says that consent cannot be generic in nature. It has to be time bound. It has to be purpose specific. And it also says that it has to be equivalent ease. It should be revocable. So if somebody asks a particular data which is not mandatory, forceful, like today happen in the IT industry, if you accept the terms and condition, click that particular, then only you proceed on any website or any particular transaction you wish to do it. Otherwise, you cannot proceed. So by default today, nobody reads the 100 lines, just click and proceed. That's not going to be acceptable under the DPDP Act. So DEPA is primarily a data empowerment protection architecture, is one of the ways through which we can leverage and use this data for a particular purpose. It uses a concept of CCR, a confidential clean room, if you can see in this particular slide. Okay, so the confidential clean rooms are used in this particular architecture. It's all technical architecture where we use the emerging technologies like confidential computing and differential privacy from that perspective. It also enables the organization creating called SRO, self-regulating organization. What does it mean is the self-regulatory organization is like Sahmati, which is functioning under account aggregator. which Smita may be aware, or many of you are aware, that Samiti exists, which has some broader perspective, but it is providing a guidelines, monitoring, storing the contracts and other things to do it. So if we see the DPDP Act, it applies into DEPA, it applies into some specific scenarios. So data sharing across uh, parties, data fiduciaries, that's where the account aggregator comes into the picture. So what we do is, it is a consent driven. And the consent provider, in this case, the account aggregator, will make sure that it provides a complete consent framework, and it takes a time bound consent, and it allows you to take the consent on whatever the accounts you have configured into it, or whatever the accounts you tell. It will send that request to those accounts, those financial institutions. It could be multiple different banks as well. Collect that data, remain a data blind, and pass it to the fiduciary or data usage or bank or loan giving agency or credit card giving agency, that this is the data which you have requested and here it comes. And the consent manager or account aggregator keeps that consent for a retention period, which is it is prescribed for. What is the another scenario? Another scenario is DEPA inference. Now, this is another scenario in which what happens is, we have to do an ad tech scenarios will come into the picture. So what will happen is that there are organizations which are data fiduciary of one type, and there are another data fiduciary, but they cross leverage each other to upsell and cross sell, but they can't see data to each other. And this also include the group companies as well. So the DEPA framework allows you to, in a consent-driven architecture, and ensuring that you remain a DPDP compliant from that particular perspective. So you have a consent, and it has to follow this principle of open, auditable, revocable, notifiable, granular, and secure. So these are the principles for the consents to be taken. But in DEPA inference, what would happen if, for example, I just take an example, IRCTC, some transactions are happening, and IRCTC can make a tie-up with any other bank, say ICICI Bank or a State Bank of India, saying that if you give me a data or some information about a person, I will be able to make a call whether this particular person can be made any offer of credit card or a particular loan. But I cannot see, the particular bank cannot see the PI data which IRCTC has provided, but it can provide an offer, and then offer reflects into the IRCTC website saying that I have a good offer for you. Will you like to accept it? If you have accepted, then you have given a consent, and then you can read more information about that, more about that offer, and then proceed on that particular transaction. Whether you accept it or not accept it is still a call to be seen. So this is how it works. But whatever happens, it happens in a confidential clean room. Nobody is able to see each other's data at all. And the third scenario is the DEPA training. So this is where the AI model comes into the picture. An AI model is foundation layer AI models are there, which are trained on a generic data. But when it has to be used for a specific purpose, it has to undergo a fine tuning. For example, for health, it has to go through a particular fine tuning, and for education, it will go differently. And within the BFSI sector, it will have their specific scenarios. For example, a CRM, if there is a call center of a particular things has to be, chatbot has to automatically respond to a scenario. But then in that case, that particular model will refer to its own website, its own methodologies, or its own data, so that any customer query can be responded with a relevant outcome, relevant response. So from that perspective, it happens. So the purpose today was to introduce the DEPA, and it is public tech. It's DPI for AI. It's open source. And we can definitely conduct a detailed session on DEPA, how to leverage, how to ensure that we are able to continue on attack scenarios. We can continue, still unlock the data and use proprietary data to fine tune our AI models so that we can have a better outcome for these situations or to implement any AI. model into our technology, into our any organization. Thank you.
Thank you, Vikram. For all, this is just an introductory on DEPA. In the next week or the coming week, we are going to have actually a detailed session on this, of which I'm going to send out a mail. But before we end, thank you, Supratim. Thank you, Smita, for helping us start off PSL Pulse, which is I wanted to start off with my friends and with the biggest experts on privacy laws in India, the PSL Pulse. This will be the first of many webinars that we are going to be doing. We would also be starting with some roundtables and podcasts very soon, of which I will send out the details. Also, if you all want any details about PSL Association, please feel free to email me or send me a WhatsApp, and I'd be happy to get on a call with all of you all. And if you all want to know about OCEN, please drop me a mail at oken@psli.org so that we can actually schedule also calls for that. We would also be having very soon a webinar on OCEN to discuss how you all could actually adopt it. But anyway, so that is all for now. Thank you, everyone, and good evening, and have a great day ahead. Thank you.
Thank you.
Thanks, everyone. Have a good day ahead. Bye-bye.
Thank you. Bye.